Welcome to this brief introduction to the UK Data Protection Act, or DPA 2018, which fully incorporates all the requirements of the EU General Data Protection Regulation, also known as GDPR. The Data Protection Act is in place to ensure that everyone's data is treated safely and only used for its intended purpose. It brings with it increased accountability, and everyone has a role within that. If we fail to comply, it could bring implications such as large financial fines or personal prosecution of individuals. By the end of this session, you will understand your own and your organisation's roles and responsibilities, the different categories of information, on what basis information can be processed, the 6 principles of the Data Protection Act and their implementation, individuals' rights under the Data Protection Act, including subject access requests, and the implications of a data incident and what action should be taken. Mother Provincial has overall responsibility for data protection, and she's supported by the Data Protection Officer. They will ensure policies and procedures are in place. Mother Superior takes responsibility in each home, supported by the Data Protection Lead, which is usually the trainer. They will help staff to understand their responsibilities and ensure that policies and procedures are implemented. It's the responsibility of all staff to follow policies and local procedures, to ensure data is kept safe and identify and report any data incidents. NKC are the organisation who support all homes in England with IT, so they will take responsibility for ensuring security around any IT systems. One of the categories of information is personal information. This includes things like name, address, contact details, gender, birth date, geographic location, or any 2 or more descriptors that could lead to identification of individuals, and sensitive information. This could include racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic or biometric information, health and a person's sex life or sexual orientation. Sensitive information is specifically defined in the DPA and is the type of information most commonly held by organisations such as the Little Sisters of the Poor. Loss or wrongful exposure of this information could potentially lead to significant harm to the individuals concerned. Therefore, data incidents concerning sensitive information would lead to increased fines and prosecution. There are a number of different grounds on which information can be processed. A contract. The processing is necessary for a contract the organisation has with an individual. Legal obligation, where the processing is necessary to comply with the law. Vital interests, where the processing is necessary to protect someone's life. Public task, where the processing is necessary to perform a task in the public interest or for your official functions. Legitimate interest, where the processing is necessary for an organisation's legitimate interests or the legitimate interests of a third party, unless the interests or rights and freedoms of the individual override those interests. Consent is demonstrated by an individual performing a clear affirmative action to agree to their information being processed. Personal data shall be processed lawfully, fairly, and in a transparent manner. That means people must be informed about what information will be kept about them, how it will be stored, and who it may be shared with. All staff should be cautious about what information is being shared with others. Residents have the right to see information being held about them. However, if a person is requesting data about another person, please ensure they have the right to know before agreeing to share. If you're unsure if a person should have the right to access certain data, please check with your line manager or local data protection lead. Personal data about staff and residents needs to be handled, stored and transmitted securely. There are occasions where it may be necessary to gain people's consent on keeping and using information about them, and this consent can be withdrawn at any point. If you're unsure over whether or not you need a person's consent, please check with your line manager or local data protection lead. Personal data shall be collected for specified, explicit and legitimate purposes and not further processed in a manner that is incompatible with those purposes. That means individuals should be informed why information is gathered about them. They must be made aware of how this information will be used, and data must only be used for its intended purpose. Personal data shall be adequate, relevant and limited to what is necessary in relation to the purposes for which it is processed. That means, as care providers, the information we hold on people, in particular residents, needs to be quite comprehensive in order to meet their support needs effectively. The information a person can access about a resident will depend on their job role. For example, a care assistant may view quite private data about residents to enable them to provide physical and emotional support. However, they will not be able to access financial information about a person, as they won't need it to carry out their role. Personal data shall be accurate and, where necessary, kept up to date. That means the information held about individuals needs to be reviewed regularly and updated if necessary. For example, care plans are amended on an ongoing basis as residents' needs and wishes change. All records must be accurate, complete and accessible to all who need it. Individuals should be able to check their own data, and we should avoid creating duplicates. Events should be recorded as they occur, and records must be easy to locate. Personal data should be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data is processed. That means data may be archived or destroyed if it's no longer needed. It must be disposed of securely, and this includes electronic copies and equipment, so consider laptops and USB sticks, for example. Data may need to be anonymised. That means removing all personal information from a record, leaving no possibility of identifying an individual from it. Or pseudonymised. That means removing all personal information, but may maintain an identifier that can trace the information back to the individual. It will depend on the purpose it is kept for. For example, audits will not contain people's names, and some services will only refer to people by a reference number rather than their full name. Personal data should be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorised or unlawful processing, and against accidental loss, destruction or damage, using appropriate technical or organisational measures. That means screens should be locked when unattended. Don't use personal devices for storing information, and the safe use of email. Never send personal information via email unless it's password protected or encrypted. And use BCC and not CC for sending out emails to numerous individuals. Never put information on a USB stick unless you've been authorised to do so and the USB stick is encrypted. Beware suspicious emails and never click on links you don't trust. Query strangers. Secure doors and locks and use principles of telephone safety. That means check who's calling and call back any known or authorised number, and only provide information to those with a right to know. Never provide login, email or password details to others. Physical security. That means clear desks, locked cupboards, locked screens when you're away from your desk, locked doors, destroying information when it's no longer required, the use of CCTV, and reporting data protection or security incidents. People security. This includes pre-employment checks, contracts of employment, agreements with volunteers and associates, contracts with third-party providers, signing and clocking in and out of premises, and following published policies and procedures. Where necessary, disciplinary processes and policies may need to be applied. Information security. That means using secure username and passwords. All passwords must be at least 15 characters long and made up of 3 completely unconnected words. Only use trusted Wi-Fi. Don't change any automatic timeout settings when activity stops. Limit access to those with a need to know, and for any concerns around IT security, please contact the Data Protection Officer or NKC. Any significant changes to the way data is processed need to be assessed using the Data Protection Impact Assessment template by the relevant person in the home and the Data Protection Officer. Changes such as the introduction of iCare or new ways of sharing data with other professionals must be assessed before they can be implemented. Individuals' rights. The right to be informed. Individuals have the right to be informed about the collection and use of their personal data. Right of access. Individuals have the right to access their personal data, commonly referred to as a subject access request. Right to rectification. This is the right for individuals to have inaccurate personal data rectified or completed, should it be incomplete. Right to erasure. The Data Protection Act introduces the right for individuals to have personal data erased. This is also known as the right to be forgotten. Right to restrict processing. Individuals have the right to request the restriction of their personal data. When data is restricted, you are permitted to store it, but not use it. Right to data portability. The right to data portability allows individuals to obtain and reuse their personal data for their own purposes across different services. It allows them to move, copy or transfer personal data easily from one IT environment to another in a safe and secure way without affecting its usability. Right to object. The Data Protection Act gives individuals the right to object to the processing of their personal data in certain circumstances. Individuals have an absolute right to stop their data being used for direct marketing. Under the Data Protection Act, anyone has the right to access their personal data. This is done by making a Data Subject Access Request, or SAR. Anyone in the organisation could receive a request for this personal information to be provided, and this could be verbal or in writing. Requests must be responded to within 1 month, and if you receive an SAR, you should immediately pass it on to the Data Protection Officer or your local data protection lead. Data subjects have the right to correct inaccuracies about the data that is held on them. They can rectify or block information, or ask for data to be erased or destroyed. Data subjects can object to information being held and restrict the use of data. Freedom of information requests. Individuals have the right to access information held by public sector organisations. As the Little Sisters of the Poor work closely with public sector organisations, such as the NHS or local authorities, we may be included in such requests. Requests need to be made in writing and should include details of the information requested. Organisations have 20 days to respond. Receipts of Freedom of Information requests should be acknowledged and forwarded to the Data Protection Officer immediately. Failure to keep data safe could lead to people being at increased risk of harm, in particular if they are vulnerable. The reputation of the Little Sisters of the Poor could be harmed, and persons responsible for data security could be personally liable, and organisations could be fined for not keeping data safe. Details of data incidents can be found on the website of the Information Commissioner's Office, or ICO. Here is an example of a recent prosecution. In the event of an actual or suspected data incident, take necessary steps to secure data, such as securing a screen that has been left open or returning care records back to a locked cupboard. Report the data incident immediately. This can be done verbally initially, but a data incident form must also be completed. Typically, you would report data incidents to the data protection lead in your home, but if they're unavailable, you can also speak to your line manager or Mother Superior.